Hello, whoever's here.
Good morning.
Good morning.
I'm here.
My name's Octavia. I'll be your court reporter.
Excellent.
Do you guys want this taken down?
Yes,
Okay, just wanted to make sure.
I appreciate that. Thank you.
Morning, Lynn.
Hey, Jared. How are you?
Well, thank you. How are you?
Okay.
Good. Hi, Leanne.
Council, when you guys get a chance, would you please chat me your email addresses?
Yes.
Thank you. Good morning, Judge Richardson.
Good morning, Ms. Winfrey. Good morning, council
Good morning, Your Honor.
and parties. All right, we are here this morning on the petitioner's motion for partial summary judgment on count 4 of the third amended and restated verified petition. I have read the briefs. So with that in mind, I will turn it over. I think Mr. Frankel, are you going to be arguing this for the petitioner?
Yes, Your Honor. And in all fairness, I do not see Nicole Wade on the line for respondent. I don't know whether she's having technical difficulties, but I don't see her name. Chris Thurman is joining. He is actually my client's son. He's obviously just attending as an observer. I see his name just showed up, but I do not see Ms. Wade or her partner.
You're absolutely right. She's not on. All right. I'm going to step off video for a moment, give her a couple of minutes.
I can tell you truthfully, Your Honor, she's pretty responsible. We're actually not only opposing counsel, but friends. So I do it out of politeness, but it would be atypical of her to intentionally or negligently miss something. So I assume there's a problem. She is.
Morning, Ms. Wade.
Good morning. My apologies all.
I was about to just start everything running. I apologize. I did not even grasp that you weren't on the line, but your opposing counsel in a display of professionalism said, "Wait a minute, Judge, we don't have Ms. Wade on the line," and I'm sure she must be having some technical difficulty because she would never just.
I appreciate that. I swear every time I pull this thing up, I have to reinstall something. My apologies.
All right. Well, we're only 4 minutes past, so we're good to go. If you are ready, I'm prepared to turn it over to Mr. Frankel to make his argument.
I am. Thank you.
All right.
Your Honor, just to start off with humor, I appreciate you're not saying that it was a rare exhibit of professionalism. And I appreciate Nicole not mentioning that as well. But anyway, as we start off, Your Honor, Nicole, the judge had mentioned that he'd already read the brief. So with your permission, Your Honor, I am not going to restate the facts unless you want me to.
Not necessary.
Okay, so this is really the second and third time that respondents have breached their fiduciary duties and breached the terms of the agreement. But we're really not talking about breach of fiduciary duties here. I think there was some distraction in the briefing and as to what the import was of the Court of Appeals decision. This case, count 4, is for breach of the partnership agreement. And the question is, did the respondents have a duty to pay a distribution that accrued when they made a distribution to Dr. Schinazi? And I think the answer is clearly yes. And so all the discussion in the Court of Appeals decision is distraction. What is really important in the Court of Appeals decision, which I think controls this case, is the law of the case. There is unquestionably, the law of this case is that the trust, the GST trust, was and always has remained, since it became a limited partner, has been a limited partner, period. End of discussion. And I think that is where the case goes. If the trust was a limited partner at the times these distributions were made, 2012 and 2013, once a distribution was made under the partnership agreement, which requires that distributions be made pro rata, and under Georgia law, which similarly holds, unless the partnership agreement says otherwise, the second that Dr. Schinazi, through the LLC as general partner, throughout RFS Partners, made a distribution to Dr. Schinazi, it had an obligation under the contract and under Georgia law to make a proportional distribution to the GST trust, period. You can't avoid that by making the somewhat simplistic argument that, well, at the time, Dr. Schinazi really thought he was the sole owner, and he had already changed his capital accounts to show that. The fact that he made a mistake or incorrectly recorded something is really irrelevant. It's particularly irrelevant here, where he made those changes with his eyes open, because the law of the case actually goes very strongly. Not only did the Court of Appeals say that the GST trust was and always remained a partner, the lower court, this court, said, which is also law of the case, that Dr. Schinazi knew as early as January 6, 2012, and again in August of 2012, that the trustee did not believe the transfer of the trust interest was valid, and that she believed she remained a partner, that the trust remained a partner. In other words, what the trial court said is that Dr. Schinazi, anything he did as the general partner of the limited partnership was done with his eyes wide open. If he chose to do anything, he knew that he had the risk that he would be running into a problem. And it's not insignificant, because remember, the first transfer was done in October of 2012. It appears to have been about 22 million and change. And it was done presumably to pay taxes that were due. But the second distribution was in April 3rd, 2013. And what's interesting is on April 30th, 2013, we filed a motion for an injunction to freeze the trust accounts. And specifically, we said in that motion that we were concerned that there might be distributions being made that would inure to our detriment. And we asked in the injunction to freeze and stop any distributions, or at a minimum, an opportunity for us to get notice and object to any distributions so that we could then argue over them. And we had a hearing in July. So the motion was filed 17 days after the second distribution of $18 million, which we were told subsequently was an investment, not for taxes. And only the second distribution ever made from this particular limited partnership in its entire history. And so 17 days later, we say we're concerned about distributions. Dr. Schinazi didn't say in his response brief, well, we've already made some, or it's not an issue. He just said there's no emergency or a reason for the imposition of interlocutory relief. At the hearing in July, 3 months later, we had the opportunity to cross-examine Dr. Schinazi and ask him, as general partner, have you made any distributions? Do you plan to make any distributions? His answer was, I don't know what we've done and I don't really have any plans. But he'd already distributed $40 million in distributions. The judge heard what she heard, apparently did not see any need for interlocutory relief, and denied the injunction. But the relevance is she ultimately said in her order several years later on the merits that he knew in January of 2012, in August of 2012, prior to the first distribution, and in our complaint, it was apparent because we sought an injunction there too, knew that we thought that the transfer was invalid. And one of the bases for the transfer being invalid was that Dr. Schinazi did not comply with the operating agreement. I'm sorry, the partnership agreement. And when I say Dr. Schinazi, I'm really referring to him in his role as the manager of the LLC, that is the general partner of the limited partnership. So when he made this distributions, he knew that the validity of the transfer pursuant to the terms of the partnership agreement was at issue. So what could he have done? Well, he could have not made the distribution. The only reason he made the first distribution was because this was a grantor trust. He didn't want to have to personally pay the taxes that were involved in the particular transaction that generated a lot of the cash. That was a choice. Remember, this is a grantor trust. It is in his best interest to pay the taxes. It will, if following through on the estate plan would generate a transfer to his daughter, that's the primary beneficiary of this trust, and save, give or take a penny, $20–30 million of taxes in estate taxes later on. So that there actually is a reason to pay taxes. That's why you do grantor trust. But for whatever reason, and that's fine, he changed his mind and felt like it was more important not for him not to pay income taxes, and avoidance of estate taxes was not his interest. He's totally okay doing that. But why did he go to the court and say, Your Honor, we've got a problem here. I'd like to pay taxes and I'd like permission while this case is pending? Why didn't he go to us and ask, will you consent to it? Because this particular trust did not allow for reimbursement, but he did nothing.
So, Mr. Frankel, I get what you're saying, but it seems to me like this is atmospheric, or at least it's tangential to the main issue, because I see where that applies on willfulness and breach of fiduciary duty and maybe as to punitive damages, but I'm not sure it's directly on point to the issue of entitlement to the distribution.
I think that's a fair question. I appreciate your asking that. I raise the issue only to point out that in the response briefs, Dr. Schinazi has basically said, it really wasn't my fault, I didn't know better. And I'm pointing out, frankly, that he should have known better. But actually, I agree with Your Honor. Perhaps I'm going to say it stronger than you. It's irrelevant. What the court held was, and it's very important, and this is the law of the case, that Dr. Schinazi, through all the entities, has to follow the partnership agreement. And the partnership agreement says that when you make a distribution in the discretion of the general partner, you must make a proportional distribution. And what the case law says, 149601A, is relevance is once you've made a distribution, the other partners are in fact stand in the shoes of a creditor. In other words, they can sue over it. You have an affirmative obligation at that point to make a distribution, and that's our lawsuit.
Does the partnership agreement say anything specifically about someone being able to or not being able to change their mind once they make a distribution? Can you make a distribution and say, you know what, I've made a distribution, now I've changed my mind, I'm going to undo it and reverse, and I'm going to put that money back? Does the partnership speak directly to whether the entitlement to distribution for all partners remains in effect, is extinguished, is revoked, anything? Does it say either way?
No, the partnership agreement is absolutely silent on that issue. So when a partnership agreement is silent on that issue, Georgia law says you look to Georgia law. Georgia law doesn't say you can reimburse and change your mind. It certainly
does it say you can't?
No. But 149601 says the moment that you make a distribution, the other limited partners stand in the shoes of a creditor. I think that's very relevant because if we're looking at recent case law and frankly, long-standing case law, but the Court of Appeals has really stated over and over and over in the past 3 or 4 years, as has the Georgia Supreme Court, the Georgia legislature knows what it's doing. And when it passes a law, you are supposed to follow the strict language of the law unless there is a law that says otherwise. This law, 149601, is very clear. There's no law that I'm aware of, case law or statutory law, that overcomes the statement in 149601A that says once you make a distribution, you're entitled to a proportionate share to everyone else, and you stand in the shoes of the creditor. And of course, that's consistent with the partnership agreement. The partnership agreement could have said otherwise. It could have said you can correct it. But I'm not aware of any law that says there's a cure provision, particularly a self-cure provision. And Your Honor, I am curious about this because there are rules regarding tax returns as to what you do or don't do. And the general rule is you've got to amend a tax return within 3 years for the IRS, or you can't amend. I don't know what's happened, by the way, for the partnership or its tax returns, that the recent tax returns of that level have not been produced to us. But we're not talking about a scrivener's error in tax year 1 that was fixed by the accountant prior to the filing of the tax return. Nor are we saying that they did an amended tax return a year later because there was a substantive error. There wasn't here. What happened here is the court ruled against them on an issue that was extant, that they knew about, and they changed their minds. In other words, they're trying to cure a mistake that they knowingly made. That was a risk they took. And by the way, I'm not sure they've cured it. There is an affidavit attached to the motion for summary judgment that says we put the money back. There's no evidence that they put the money back. It's my understanding, and it's not evidence, that it was an investment made by Dr. Schinazi and also an investment made by the limited partnership, and that some cash was paid out to pay taxes. But all of this is subsumed in some proportional return of some asset, an investment asset done through another LLC that was returned to the trust to be allocated at a future date. That is what was told to me privately, and I don't know whether that's true or not, but I haven't seen any evidence to that effect. More importantly, whether I've seen it or not is irrelevant. It's not in the evidence. It's not in the record. And so nothing has been shown to you that in fact it was paid back. And that reason alone, even if you were allowed to cure, would answer the question here, because they haven't proved they've cured. Having said that, though, I really think the fundamental question is, can you cure? Now, we have a doctrine, and I forget the statute, and I'll tell you, and I can send it to you if I can remember it, but it's called the voluntary payments doctrine. It's under the contract code 1331, I believe. But it's called the voluntary payments doctrine. It's very simple. It says that if you pay a debt and you don't have an agreement that says you can pay it under a reservation of rights, that's a voluntary payment and you can't get it back. And the reason I think that statute is relevant, and I'm really trying to respond to Your Honor's question, which is why I didn't include this in our brief, is that's an explanation of Georgia law. If you make a payment and you're not deceived by the other person, and there's no allegation of fraud or deception on the trustee's part here, that would be a voluntary payment under a contractual obligation that you can't get back if this were a payment of a debt or something else. I'm curious whether it's directly applicable here, but I'm most curious. The law has been litigated on that oftentimes. The rationale, the public policy is that is a debt that you made the payment voluntarily, and you can't change those rules unless you had an agreement. I think the applicability here is the partnership agreement doesn't have an exception that says if you make a distribution and you determine that for some reason you're changing your mind, good reason or bad reason, you can always undo it. Here's how you do it. And that there's nothing stating there. So basically, this was a decision made in the discretion of the general partner, and the general partner has to take the risk. Now let's go back to the partnership agreement. This court has already held, affirmed by the Court of Appeals, that the partnership agreement controls. And Judge Bonner's decision, approved by the Court of Appeals, said you must follow it literally. You must follow it literally. And she noted, frankly, that Dr. Schinazi wasn't all that innocent here. That was not necessarily relevant or necessary for her decision, but she noted that he knew it was at risk. But nonetheless, regardless of whether he knew or didn't know, he had to follow the rules. He didn't. And the law of the case is the trust was a partner, period. If the partnership agreement wanted to have a cure provision, or if Georgia law wanted to have a cure provision for partnerships, it could have put it in the statute. There's many things in the statute that frankly are odd to me. There's also many things in the partnership agreement that are odd to me. One of the things we talked about in the underlying case was the issue is who could sign, when can you sign, and all those things. How do you comply? And one of the things we noted to the lower court was there was an unusual power of attorney provision in the partnership agreement that gave the partner authority to do certain things. And this particular agreement has great authority given to the general partner, perhaps more than normal. But the court said, that's okay. That's in the partnership agreement. There could have been a provision in the agreement that said, if you do a distribution, you can reallocate, that the provisions of 14.9601 don't apply. There's lots of things you could have done. You could have put in a tax provision that said if you change for taxes, but taxes only. You could have put in a timeline that says you can always amend. There's lots of things you can do. I do remind you, of course, that the trustee here did not write the operating agreement. This was written by counsel for, I presume, Dr. Schinazi when he created the entity. Our client didn't get shares till later. But my point is, we are stuck with, legitimately stuck with, and so is this court, the partnership agreement controls. And I appreciate your opening question, which was, well, is there any statement in the partnership agreement that says you can't do it? In other words, you said very politely, and I'm going to say it with a smile, can you prove the negative? And the answer is no, but the real answer is that's not my job. The law is very clear that the partnership agreement controls, and I would posit to you, the real question is there any authority that authorizes you to cure? Because absent that authority, the concept of cure is an exception. It's a defense, so to speak. It's something that the law does allow. So, and oftentimes, and I give you a simple example, in almost every partnership agreement I've had where you can terminate a partner or terminate a shareholder or terminate an employee, there's a contractual cure period. If you do that, you've got to give notice, 30 days. There are ways to put in a cure right, but there wasn't one here. So I would begin where I will end where I began. The law of the case is you must follow the partnership agreement. The partnership agreement doesn't have a cure provision. And even if it did, there is no evidence in the record that they cured. So I do believe that we are entitled to summary judgment as a matter of law. The dollars are straightforward. We've put it in our brief. The principal amount due, if you just use the percentages, would be on the October 2012 distribution. My client would be entitled to $34,696,618.54 on principal. And on the April 2013 distribution, the trustee would be, I've said the wrong numbers, I apologize. The trustee would be entitled to the October 2012 of $59,046,906.85. And the principal on the April 2013 distribution would be $46,742,871.64 for a total of $105,789,778.48. That's the principal that's due. It is liquidated under Georgia law. Liquidated claims attract prejudgment interest. I can tell you the prejudgment interest that obviously would have to be updated based on if the court rules in our favor when the judgment is issued. But as of today, the interest is running at its 7%. It's a daily interest on the October of $11,481.34. And on the April 2013, it is a daily interest of $9,088.89. I've put it in a spreadsheet, which I'm more than happy to share with you or the other counsel. But again, that will be based on the judgment, but the total interest due would be $60,463,359.85. And the total, both interest and principal, would be $166,226,138.34. And I would respectfully suggest that the law of the case dictates that we are entitled to partial summary judgment on count 4, and that liquidated damages and the principal amount plus interest should be awarded. I would note that we do have a claim for attorney's fees under 13611 that we would want to reserve for the court. And if you are inclined to rule in our favor, we would ask for a partial summary judgment under Rule 54B so that we could go ahead and collect on the judgment and then reserve the issue for attorney's fees for a later hearing. And I would note that if we were successful, we probably would, obviously subject to appeal, dismiss the other claims.
So let me ask you this question, and obviously this is more of a practical question and not a legal question. If I grant judgment on count 4, what economic impact does this have on the trust, on RFS?
The answer is I don't. The truthful answer is I don't know as we sit here today. When we filed the complaint, obviously interest was not. It was much lower, and given on the last accounting we had, there would be sufficient assets within the partnership, though you might have to sell many of them. There would be sufficient assets to pay it. I do not know the current status of the partnership. I mean, on the one hand, we've had a huge economic downfall that may have brought it down. On the other hand, the assets were growing at a great rate, and there may be sufficient. I don't know the answer. But at the time, in November of 2017, when the complaint was filed, there were sufficient assets. We have gotten some subsequent accountings. I just don't recall the most recent one, but the last one I recall seeing, there were sufficient assets.
So at least a partial liquidation of assets, if not complete liquidation.
Your Honor, that is correct.
Okay. All right. Thank you, Mr. Frankel. Let's hear from Ms. Wade.
Thank you, Your Honor. I don't want to.
Your Honor, I do have a comment, and I apologize. My partner reminded me that 13113 is the voluntary payments doctrine, and apparently I don't remember the brief that she wrote so beautifully, but it was actually included in a footnote. But the voluntary payments doctrine is 13113, and we must have made that analogy before, and I didn't remember.
All right, you were just about to get started, Ms. Wade.
All right. I don't want to tread back over ground that may have already been discounted, but I do want to just take a couple of minutes to address this issue about the breach of fiduciary duty and the allegation that, Dr. Schinazi knew what he was doing and his eyes were wide open. I just want to take 2 minutes and address that very briefly. Because it's interesting that Mr. Frankel started by saying, this is yet another breach of fiduciary duty. And then he says, well, the breach of fiduciary duty isn't relevant. It's a distraction. But that is exactly what they're asserting here, that there is another breach of fiduciary duty. And the Court of Appeals was very clear that if there's a breach of fiduciary duty, they have to prove that in court. They have to prove that to a jury. And that simply hasn't happened. There's just this attitude that this assumption that as though they have a judgment for all these, tens of millions of dollars. And it's just not true. There is no judgment. The only ruling that has been made, the only thing that's final in this case is the answer to the breach, is the answer to the petition for declaratory judgment. The question was whether or not the trustee remains the owner of the limited partnership interest. The answer is yes. Now we go from there. That's the only answer that was given. We go from there now. As a result of that, and the whole point of that is so that then the parties know where they stand, right? They know what their legal rights are and they can act accordingly. That's exactly what happened here. As soon as that was final, Dr. Schinazi in his position as general partner and in his individual position as an owner of a limited partnership interest, reassessed everything. You know, there's this this accusation that there's no evidence in the record. There's evidence of Dr. Schinazi's affidavit, which we filed, in which he says very clearly that the reasonable capital needs of RFS partners do not now and have not ever permitted distributions in the amount requested by the trust. He made very clear that he has transferred back to RFS partners assets sufficient to repay any distributions made to him after January 2nd, 2012. That's the only evidence that is in the record about the status of the distributions. And anything that has to do with whether his eyes were open and all these sorts of things, that goes to the breach of fiduciary duty and whether he had reason to do what he did. We have plenty of evidence on the other side that he did. He had counsel, he had lawyers advising them. He didn't prepare these documents on his own. And that's in the record. He completely relied on counsel in doing all of this. He had a firm belief that the fact that Ms. Eden responded and said, no, that's not good enough, that made no difference. The fact that she objected was irrelevant because the trust instrument was very clear that his right to reclaim those assets, to reacquire the assets, was to be exercised without any fiduciary oversight. And so her statements at the time were irrelevant. All those are the things, and I won't go into all of the rest of it. I just want to be clear for the record that for every single thing that Mr. Frankel said to support his claim that Dr. Schinazi knew that there was a question and he shouldn't have done this, that goes to the breach of fiduciary duty. And we have answered.
There's another part of that though that I think, because one of the things I'm trying to weigh here is, first, am I legally constrained or do I have some discretion? And I'm not sure yet whether I have any discretion or whether this is absolutely a case where that can be decided based on the law and I have no discretion. But to the extent that I have discretion, I have to consider, whether in fairness, a party knew or should have known that they were making a risky bet. And I think in the context of legal disputes and litigation, potential litigation, and a fight over ownership interest in the partnership, making a distribution at that time, whether you have legal advice or not, and I don't know exactly what that legal advice or not, you have to recognize that there is a risk that it could have unintended consequences down the line. Would you agree with that?
Certainly. I would answer that in a couple of ways, though. First of all, with all due respect, it's not up to the court to determine whether or not that risk was reasonable or unreasonable. That's a jury question. It's a fact issue as to whether, to the extent that the court decides that is the question to be determined, and I don't agree that it is.
Well, I don't think that's the question to be determined, but I'm trying to weigh the equities because what Mr. Frankel is arguing obviously will result in it seems to me will result in a partial or full liquidation of the trust, which seems which seems to me to be a rather extreme remedy. And so when I consider if I can even consider, I'm not sure I can, if I can even consider whether such a remedy is fair or just or not, I'm thinking also about, well, when the decision was made in the first place, do you apprehend where this could go if it's ultimately determined that transfer or elimination of the partnership interest was valid. I don't know that I expect you to have an answer to it, but I'm trying to be transparent as to what's going through my mind here. And if you want to try and push me in one direction or the other, I'll give you an opportunity to do that.
I appreciate that. And I would like to push Your Honor in one direction or maybe the other, depending upon how you frame the question. I'll skip to this point, which I think is very relevant to what Your Honor is saying right now. And that is that Mr. Frankel talks about that we have to follow the partnership agreement, the limited partnership agreement, which is true. The limited partnership agreement gives complete authority to the general partner. And limited partner may not like the terms of this agreement, but nonetheless, she bought the limited partnership interest for the trust and has spent the last couple of years arguing that the limited partnership agreement controls the relationship. So there's no question that it controls. The limited partnership agreement, the provision that talks about making distributions is very, very clear. And I just want to read this one sentence. The cash or other assets of the partnership may be distributed by the partnership to the partners at such times and in such amounts as the general partner may reasonably determine in proportion to the positive balances, if any, standing in the partner's respective capital accounts, taking into account the reasonable capital needs of the partnership. There is no other limitation or requirement on the distributions in the statutes or in the partnership agreement other than that. That is the sole limitation. There is nothing, as Mr. Frankel has admitted, that speaks to whether to return or whether you can't return. So in this case, the fact that there is nothing that limits the right of the general partner to accept back a distribution means that there is no restriction on that. And
give me that section number again of the partnership agreement.
It's 4.3. It's under section 4. I don't have the page up. 4.3, distributions. 4.3A is distributions to partners. And that's it.
Your Honor, that's on page 7 of the agreement, if that's helpful to you.
Thank you.
All right.
If we want to talk about, talking about the voluntary payments doctrine or talking about, none of that stuff is relevant. We're not talking about a situation where a debt was paid and now the person doesn't want to give it back. Dr. Schinazi gave it back. You want to talk about, you have to think about what the consequences are when you take an action pending this legal proceeding. The consequences are you have to give the money back, and that's what happened. The consequences are exactly what he knew they would be. You have to give it back. Okay, turns out this wasn't yours. You have to give it back. And that's what happened. The distribution that was made at that time, and part of the problem with the analysis by the trustee is that Dr. Schinazi made that distribution at a time when he believed that he owned virtually 100% of the funds in the limited partnership. What the trustee has done is go back, and she says, not, okay, you made this amount of distributions, right? You made $40 million of distributions and we get our share. Turns out I own 76% of that, and I want my 76% of that share. I could see that argument, frankly. The argument that she's made is completely, it demonstrates nothing other than Mr. Frankel's incredible creativity and brilliance, frankly. They've said the distribution was this amount. Well, you only own 25%. So we get what would have been 75% of that. If the whole thing, you can't do it that way. There wasn't, as we put forth in Dr. Schinazi's affidavit, no distribution in that amount ever would have been made. It could not have been made. there were not sufficient assets in the limited partnership to even make that sort of a distribution. So it simply could not have been done. It's like I said, it's creative. The only thing that I think could possibly have been done was to argue that of the distribution that was made, 76.8125, whatever the percentage is, should be transferred to the trust. But again, even that doesn't work, because what happened, the consequence was that that amount was voluntarily transferred back to the limited partnership by Dr. Schinazi in its entirety, as set forth in his affidavit. We didn't attach a lot of financial records because there was no reason to. There's no evidence to the contrary. And filing all those things under seal is complicated. As Mr. Frankel pointed out, his client receives periodic accountings of the trust. We've had no complaint that anything was done wrong. His client should have the financial records. If they had something to base an objection on, they should have filed it in connection with this summary judgment motion, and they did not. So the only evidence in the record is that all distributions that were paid out were returned by Dr. Schinazi. He voluntarily repaid them. The general partner voluntarily accepted them, and everyone went about their business. Because despite the fact, and it's almost a legal fiction in a way, to go back and say, no, at all times, this interest was owned by the trustee. The fact is, and as the Court of Appeals recognized, that interest was actually transferred on the books and records of RFS Limited Partners. And so to the extent that that transfer, the mere transfer, I think the Court of Appeals referred to it as an invasion of the trust's interest, to the extent that there are damages caused by the fact that that transfer was actually made, that's something that has to be established in a jury as for breach of fiduciary duty. And it becomes relevant what Dr. Schinazi knew and what he thought and what advice he got and all of those things. None of those things are at issue here. And I would contend, nor is a balancing of the equities by the court, because the question is, the point is, it's up to the general partner. And the general partner has balanced those equities and has made that decision and has said, no, this distribution would not have been made, should not have been made, and now has not been made. Because just as with the decision on the declaratory judgment, just as the ownership interest had to be transferred back to the trust on the books and records, so too the distributions were transferred back. And so now everything is as it was before. Before Dr. Schinazi, they would say, wrongfully transferred the interest on the books and records of the limited partnership. And that's where we are. And there is no basis for a distribution when none was made in effect. That's the sum of where we are now. It's an interesting position because the trustee doesn't have a right to obtain distributions from the limited partnership and obviously wants cash. Although interestingly, that's what was done at the very beginning of this that she objected to, and she claimed she wanted the ownership of the limited partnership interest. Well, she has to be subject to the limited partnership agreement. And what that says is that it is up to the general partner whether and when to make distributions, and it is solely up to the general partner. I'll stop unless I've failed to answer any of the court's questions. I think that's the key.
So just so I'm clear, under 4.3A of the partnership agreement, you believe that that provision gives the general partner the authority to undo a distribution, to claw back a distribution?
In the event where the partner is voluntarily making the payback, absolutely. If it were a question where the partner were resisting it, I don't know. That's a different question. So I'm not, and that's not an issue here. So I'm not taking the position that it would or would not. I don't know. What I do know is that, yes, we believe very strongly that because there's no limitation, but instead it says that the general partner has sole discretion to determine whether and when there should be a distribution. Yes, if the limited partner is willing to pay back a distribution that was made, the general partner can accept it. There's just nothing that would limit that. Nothing.
Does it have to have a limitation? Because one of the things I'm wrestling with is we're operating sort of in the wilderness here. We're operating in a unique circumstance where you have a transaction that was made that was later declared void. And there were obviously additional transactions that followed based on that void transaction. And it's not explicitly covered under the partnership agreement. And I don't believe it's explicitly covered under Georgia law. So the question is, do you have to have explicit authority, or can you do it if there's no authority counter to it?
It's the latter. And I would just point out that under the partnership agreement, and as Mr. Frankel pointed out, this partnership, the limited partnership agreement is very broad with respect to the powers of the general partner, very broad. And that's just how it is. I will point out another two provisions that I think speak to this, section 3, 3.1 and 3.4. 3.1 says all decisions relating to the business and affairs of the partnership and all designations and elections required or permitted to be made by the partners under this agreement shall be made by the general partner. So cut out that middle part, which doesn't really apply. All decisions relating to the business and affairs of the partnership shall be made by the general partner. I contend that gives the general partner the absolute discretion to make any of these decisions, such that, to answer Your Honor's question, if it's not prohibited, then it's up to the general partner. The other section is 3.4, limited partners' participation in management. The limited partners, in their capacity as such, shall not participate in the management of the partnership and shall have no right or authority to act for or bind the partnership or the partners. So again, that's very broad with respect to, and very clear that in this particular limited partnership, which we all agree is governed by this document, the general partner has absolute discretion and the limited partners have no role in management. Management would be including determining when and how to make a distribution or whether to make a distribution. It simply cannot be the case that a limited partner under this agreement, that a limited partner could force a distribution that the general partner has said it would not make, taking into account the capital needs of the partnership, that would decimate the partnership or force liquidations or do anything to impact the capital. That decision is clearly reserved to the general partner. And so, yes, without some prohibition, and there is none, we all agree on that, there is no prohibition, the general partner is entitled to take whatever actions are in the best interest of the limited partnership, including with respect to distributions. And accepting the return of a distribution is one of those things.
All right, you've answered my question.
Thank you.
All right. Mr. Frankel, you get the last word here.
I wish that were true at my house. Let me start off.
This is live streaming on YouTube, so somebody can come back and check the video.
I'm going to take the fifth on that. I do want to clarify something, and it may have been that I misunderstood the court. When you talked about the liquidation, you said the liquidation of the trust in order to pay this. It's actually the liquidation of the partnership.
Yes.
The trust would retain the assets. I just wanted to clarify that. Second thing I wanted to clarify, because I'm not sure I understood, is that My opposing counsel said that we had rejected cash at the beginning. I'm not sure I understand what she's talking about, but the original substitution, the original acquisition to get its stock back was in exchange for a promissory note that frankly wasn't payable for 25 years. Therefore, it was a 25-year delay on cash. To the extent that's what she was trying to say, I candidly didn't understand. But there was no cash offered, ignoring whether it was the right cash or anything else. It was a balloon note 25 years later. Let me get to kind of the important part. We started talking about, both I did and opposing counsel, Ms. Wade said, you know, this looks like and smells like, and the Court of Appeals said this is a breach of fiduciary duties. I don't think I was clear on that, and I want to be very clear. There is a breach of fiduciary duties claim. We amended the lawsuit to allege that, but that's not the claim we're asserting here. There's also a breach of the partnership agreement. We are entitled to argue in the alternative, and we're lawyers, and we did. The reason we filed the motion for partial summary judgment really gets to the court's question. We wanted to go in the easier route, obviously. And you asked the question, are you legally constrained, or do you or the jury, giving Ms. Wade her due, have discretion? And the answer respectfully is, you are legally constrained. That's the law. And when we look at the provisions that were pointed out, section 3.1 that says that the general partner manages the partnership and that the limited partner doesn't have authority. True, irrelevant, but true. It doesn't say you can unring a bell or override Georgia law. So we cited on page 10 of our brief, Georgia Corporations by Kaplan. And Kaplan says that you, and I think it was, I may have it wrong, section 17-27, but talks about the fact that you can't force a distribution to come back or require a distribution to come back. And I think that's relevant when we look at section 4.3. So Ms. Wade said that section 4.3, the discretion to make a distribution, really, this is her interpretation, and I think it's valid actually, says that controls where and when you make a distribution. And that's exactly right. Where and when you make a distribution. It doesn't say anything, certainly not expressly, but I would argue impliedly, doesn't say you have the authority to undo a distribution. Remember, when he's undoing the distribution and voluntarily paying it back, he's not doing it in his role as a general partner managing the limited partnership. He's doing it in his role as a percentage partner who owns something that the limit, in the role as a limited partner paying back what the limited partner got. And interestingly, that's their problem. A voluntary payment back is not being done by the general partner. It's actually the purported limited partner voluntarily paying their money back. And that's a very different animal. And it's particularly troubling here. So Ms. Wade refers to the trust ownership of a limited partnership interest as a legal fiction. It wasn't a legal fiction. The law of the case says it was a reality. And Ms. Wade points to that the plan, the trust, the language, and all of that, and the partnership agreement was done with the advice of counsel, and that we've got to live with it because we accepted it. Correct again. But what she didn't say was the decision to make the distribution when the law of the case says that they were aware that there was an issue regarding the validity of the transfer. And by the way, our complaint, the original complaint, sought a deck action, a declaratory judgment. I'm sorry, I sought a declaratory judgment as to the validity of the transfer. And the court held that ruled in our favor and said that and issued a declaratory judgment that the transfer wasn't valid, and we always remained. But my question is, knowing this, and that's the law of the case. The law of the case is everything that was decided by the judge in that case is binding on the parties till the end. Why didn't counsel, why didn't Dr. Schinazi when he made the distributions, seek counsel either from Nicole's firm or some other tax counsel or anyone else and get advice on this? Why didn't he go to the court? And when he made the decision to return, I can't see anything in the partnership agreement that authorizes a clawback. I don't see anything in the partnership agreement that overrides the statute that says once you make a distribution, it must be proportional. And now the limited partner steps into the shoes of a creditor, the right to file a lawsuit for breach of contract. That is the moment it happens. I don't see any authority that says you can unring. You can, using your words, Your Honor, claw back. And I'm particularly troubled when you have an agreement, as Ms. Wade pointed out, that is extremely broad with authority. If you give a broad authority and don't announce authority that is very different than Georgia law, and certainly no reported decision or statute, and you don't specify the authority, the obligation is not on the opposing party, certainly under contra pro referendum, the one who signed the document without having any ability to change it. That should not be construed against them, and that they have to come forward and say, but there has to be some express prohibition. It's the exact opposite. You have to have the authority either under the partnership agreement or under Georgia law. And opposing counsel is not appointed to anything in the partnership agreement other than general authority, nothing in the Georgia code, and no reported decision. The only thing we were able to find on the point that goes to the point is a corporations code. But the Georgia legislature and the Georgia Court of Appeals and Supreme Court is clear. Statutes must be given their plain meaning. And the statute at issue here is plain. And the decisions of the court that we cited, of the Georgia Court of Appeals and Supreme Court, have applied this statute, literally, once a distribution is made. Frankly, this accords with the partnership agreement, and it makes total sense. And this accords with the Georgia law on corporations and partnerships. Yes, the general partner has broad discretion to make a decision as to when and what amounts to make a distribution. That's totally clear. But once they make it, it must be proportional to the capital accounts. In other words, to the ownership interest. And you can't say, I relied on a false corporate account or a capital account. The court has said, no, that capital account was wrong. And I think it's particularly important here, though it's not necessary for you. I think you are legally constrained. They did this with their eyes open. It was a risk. We all make decisions on risk. Many of us, when you go and invest, the question always is, how risk adverse are you? I've never really liked that question when I'm asked to invest because I don't know the answer. But there were many things that could have minimized this risk. And Ms. Wade says, if Mr. Frankel had just said, because you got your equivalent almost at 22% or whatever it is, 28%, we won our 75%, that would have been better, but he didn't do that. Actually, that's exactly what we did. It's exactly what we said in the complaint, verbatim almost, and it's exactly what we said in our motion. In fact, the numbers play out. We even attached a percentage where we showed how it was done in a footnote. It was very clear. If you made a proportional distribution of X, we're entitled to our proportional distribution. So if you got a 25% distribution, we're entitled to a 75% distribution. The decision as to whether you did or didn't have the funds, that was in the discretion of the general partner. How much he gave was his discretion. And that's what he chose to do. It was a risk. Yes, it may, I don't know the end result, it may result in a partial liquidation or not, but I must ask the question, why is that bad? Why is that bad? The trust was created by Dr. Schinazi for two reasons. One was to provide, presumably out of love, for the benefit of his daughter. She is the sole current beneficiary of that trust. And the second was to effectuate, with very good counsel, substantial tax savings on an estate tax, which by the way, is a very substantial number. Now, Dr. Schinazi has decided he doesn't want that tax benefit. That's fine. And I assume he's not saying he doesn't want to benefit his daughter, but the trust is going to own the asset, whether it owns it as a limited partnership or whether it gets a distribution. And the beneficial interest to the daughter, their mutual daughter, still exists. So I think we come back to the question: what authority did the general partner have to claw back and overlook Georgia law? And I think the answer, though I understand that Dr. Schinazi wouldn't like it, is you don't have that authority. Georgia law doesn't give it to you. The partnership agreement doesn't give it to you. And Georgia law says very clearly, once you exercise your authority, your discretion to make a distribution, you have an absolute duty, absolute, unringable, to make a proportional distribution to the other limited partners. That was the decision he made. And the alleged cure by him and his role as a limited partner doesn't change that result, because that action was as a limited partner, not as a general partner, not under the authority. And to quote my opposing counsel, section 3.4 says very clearly, a limited partner can't change the management of a partnership.
So answer this question for me, Mr. Frankel. Assuming I agree with your argument about authority or lack of authority for a clawback, tell me why the calculation should not be that you take 70% of the 40 million in distributions.
I think that is a very fair question. And candidly, and Ms. Wade and I have discussed that, the answer actually goes back to section 4.3. And section 4.3 says it has to be a proportional distribution. Once you make a distribution to somebody else, you must make a proportional distribution to the other. It doesn't say you can recalculate it and say, change the original distribution and then bring it down and make it proportional. That's what the agreement says. Their discretion doesn't say you can recalculate it. He didn't make a total distribution of $40 million. Remember, it was 22 and 18. He made a distribution to himself of that amount. And proportional, I think it's pretty clear, that means that it's pro rata based on your ownership interest. If he got 40 million based on his ownership interest, give or take a penny, 25%, then a proportional, a pro rata based on the ownership would in fact be 75% of the whole of the value, not the smaller. I could see the attractiveness of that, but I think that is inconsistent with section 4.3.
I'm having a hard time finding it inconsistent because I'm looking at the language. And again, we're dealing with a legal fiction. We're dealing with him distributing it, deciding on the distribution at a time where the court had not determined that he was not the sole part, that there was not just one partner. So there is one total distribution in the amount of 40 million. So if somebody says, well, wait a minute, there was another partner there, it seems to me there are two reasonable constructions of that. One is your construction, and the other is Ms. Wade's construction.
And I think the answer—
I'm not sure there's something that definitively says it has to be one way or the other.
I would respectfully suggest that you need that your interpretation of 4.3 is not correct. When we look at because it says in proportion to the capital accounts, and the court has held the capital account at that time was in fact the 75-25, and it says in proportion to the capital account. And if we look at the code section, it says if you make a distribution to one partner, you must make a proportional distribution to the other partners, and they stand in the shoes of the creditor. I think reading those together says it has to be proportional to the capital account. And they made the distribution to one person, it's not an aggregate distribution. Now, I understand the use of the word legal fiction. And I understand that they did not know what the answer would be, but the court has already answered that. The answer is at that time, the trust was, give or take a penny, a 75% owner and had a 75% capital account. Dr. Schinazi exercised his discretion. That is a decision he made. He did not have to make it. Nothing forced him to make it. But when he made it, he knew that at some point, whether he was right or whether he was wrong was going to be determined. It was an extant issue. And he made a decision to go forward. He had a lot of choices. With discretion comes responsibility. He made a decision. I didn't make that decision. My client didn't make that decision. And I respectfully suggest when it says the partnership has the discretion to make a distribution in proportion to the positive balances, that's what he did. He made a decision to make a distribution total. Remember, it was three separate ones, but it totaled 40 million. He made a decision to distribute to one and only one beneficiary, a limited partner. That was his decision. And Georgia Code 14960 says otherwise, therefore, it has to be you stand in the shoes and you get your proportional share, period. So I actually do think you're constrained, and I respectfully disagree with your construction, but I will acknowledge that's the question.
All right, Ms. Wade, you had one follow-up?
Two brief follow-up points, Your Honor. The first, I just wanted to clarify, and I think we were just talking past each other, but I just wanted to be clear when I said that the trustee had initially turned down cash there was in fact a promissory note, and it did have a balloon payment, but as I know Mr. Frankel will concede, it also had annual interest payments due, which were in $3.5 million, I think, a little over $3 million annually. So there was some cash component, although he's correct, it was a balloon payment of the principal. I just wanted to clarify that point. And just then to follow up on what the court has been discussing with Mr. Frankel, I disagree completely with his assessment, and I will just point out briefly because his assessment ignores the part of the sentence that says taking into account the reasonable capital needs of the partnership. The decision of the general partner at the time of those distributions was that it was acceptable for the general reasonable capital needs of the partnership to make distributions totaling 40 million, period. It was not within the general partner's, the general partner did not make a determination that it would be distributing hundreds of millions of dollars. And Dr. Schinazi's affidavit speaks very clearly to this about what the general partner determined. So reading that the way Mr. Frankel reads it, you would be forcing a distribution from the partnership, the general partnership, the limited partnership, that the general partner did not deem was appropriate to make. I submit to you, there is absolutely no support in Georgia law or anywhere else for that sort of a proposition. Thank you.
Your Honor, may I have the last word only on that issue?
Yes.
I appreciate my opposing counsel pointing out the reasonable language, but frankly, I think she's making an argument. The reasonable capital needs of the company were taken into consideration. That's what he's supposed to look at, but his discretion is actually absolute. He exercised his discretion, and we can argue whether it was reasonable or not for him to make that determination when the issue of whether he did or didn't own the limited partnership interests was valid or not. Remember, he's making the payment to himself and the general partner. Okay, he's not making it to somebody else. He understood the risk. So the reasonable capital needs, with all due respect, what he was doing was taking money out because he could. That was his risk. But the partnership agreement says in proportion. The reasonableness is what he's supposed to think about. And Ms. Wade has already argued that his discretion was absolute, and it was. That's the problem. He made a decision that was a bad decision in hindsight. That is what we all live with as human beings.
All right. Let's take 5-minute break. I think I'm ready to at least give you some preliminary guidance on this, but I want to have a discussion with Mr. Townsend first. So
Thank you,
let's take a All right, we can get everybody back.
And Your Honor, I want to apologize. My partner, Leanne Gilbert, I was on another calendar call, and so she went to that calendar call. She's covering for me, which I greatly appreciate. Judge Glanville apparently had some emergency, and he shifted us from 9 o'clock. So I apologize that she's not here on the line anymore.
All right. So on the motion as to count 4, I think on the entitlement to relief at this time, I'm going to deny the motion. I think the powers of the general partner under the partnership agreement were broad enough that with a partner's consent, the transaction can be undone and the distributions clawed back, as I said before. I do believe, though, that there is at least an issue of fact as to whether that was fully effectuated, that clawback. I know Mr. Frankel alluded to this. He said that, well, they say they did it, but we don't have any documentation or paperwork to prove that that happened. And if it's in kind, there may be questions as to valuation. If it's not done properly, then I think we have to come back to the proportional distribution, and we'll have to come back and I will have to determine what that means, whether that means 40% or 70% of the 40 million, or whether that means 40 million is the 30% and then another 100 million on top of that. I don't think I need to make that determination now because I don't think we're there yet. I think that the proper course is to limit my ruling to a denial on the motion for summary judgment, still acknowledge that there are disputed issues of fact as to whether that clawback actually occurred. And I'm going to ask Ms. Wade, since you are essentially the prevailing party, if you would draft a proposed order, run it by Mr. Frankel, and hopefully y'all can agree on what it should look like, and then send it to Mr. Townsend, and we'll look at it. And if y'all both approve of it, then we'll likely get it entered without alteration.
I will certainly do that.
Your Honor, I would make this motion later, but we're sitting here on Zoom. We would ask, because this is such a controlling issue, for a discretionary appeal. I believe this will be interlocutory because it's denial. I'm just telling you in advance if you wanted to ask any questions, because the time frame is so fast. It's got to get a certificate from you within 10 days. So I appreciate your ruling and I obviously respect it, but we would seek an immediate review because moving on in the case will be so expensive absent a ruling on this issue. I do think it's a controlling issue.
Ms. Wade, do you have a position on that right now, or do you want to talk about that with your clients before expressing any opinion?
I would need to talk to my client. I will tell you, the idea of going back up on appeal a third time without trying the case seems a little excessive, but I would have to discuss it with my client before I take an actual position on that.
And let me ask you this, Mr. Frankel. If you prevailed on this, if you ultimately prevailed on this one issue, do you give up the right on the breach of fiduciary duty claim, on claims for punitive damages? You're not giving up. The case wouldn't just go away and you give up those claims.
Actually, Your Honor, we would have to evaluate it. I do think that the collateral source rule, you can't get double damages arising out of similar events. I'd have to think about it, but I do think there would be a good argument that we would, at the end of the case, if we won on both issues at trial, for example, and one on the breach of fiduciary duty or one on the breach of contract, we would have to elect ultimately which one we're collecting on. So I think if we were to prevail on the breach of contract at this stage, we likely would withdraw all of the other claims other than the attorney's fees, because that's a more practical answer. Obviously, we're not there yet. But I think we would be constrained by the law to ultimately elect a remedy, even though we pled in the alternative.
All right, so it's going to take a minute before I enter an order on the motion for summary judgment. That's when your clock is ticking.
Yes, Your Honor.
So if either side wants to inform me further by letter, brief, or otherwise as to whether I should grant interlocutory review, please do that. Please submit that at the time you submit the proposed order. And then I'll make a decision from there based on what I hear from both sides.
Thank you, Your Honor.
Thank you, Your Honor.
All right. Any other business that we need to take care of today?
I don't think so today, Your Honor.
All right. Well, I thank you both.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Everybody have a great day and stay safe out there.
You too.